Gowdy on behalf of the Appellate, Shelley L. Hall, PA.MD, doing business with Island Pediatrics, and that's how I would refer to my client presentation. Well, there were several issues raised in the brief. I think the real meat of this appeal is over whether the claims presented to the trial court were inextricably intertwined, and so that's where I'm going to focus my argument. I'm happy to answer any other questions if you have them on the other issues. But the real meat of this appeal is whether Dr. White's entitlement to her back wages, which does entitle her to attorney's fees for that claim under Chapter 448 of Florida statutes, whether the wages claim is inextricably intertwined with the remainder of the case that was tried to a jury. The Florida Supreme Court established in Bolton that to be inextricably intertwined, the claims must be alternative theories of the same wrong. And when you look at that, some examples might be you had a breach of contract claim and a claim for quantum merit or account stated. You can't recover twice for those. It's the same money that you're attempting to recover. But they're alternative theories of the same wrong. We saw the same sort of thing in the Angelina John's case, where you had a claim and a counterclaim that were both claiming breach of contract, and only one of the parties could be right. And so there you had alternative theories of the same wrong. But that is not what we have in this case. What we have here is a claim that actually proceeded for over a year without any knowledge or evidence of the wage claim that ultimately entitled Dr. White to recover just over $900. This was primarily a dispute over whether Dr. White and her LLC were entitled to collect damages as an independent contractor following her termination of her relationship with Island Pediatrics. The claim was proceeding along those lines, and it was discovered that at the very beginning of her employment relationship, she was underpaid $900 under a totally separate formula. Proving that she was entitled to the $900 in wages or the $20,000 in independent contractor damages, they don't prove each other. It's entirely different facts. And so her establishing that she was entitled to the $900 in the past wages didn't prove that she would get the independent contractor damages. It didn't prove that she didn't herself breach a contract. It didn't prove, when we talk about counterclaims, that she didn't breach the contract, that she didn't abuse process, that she didn't tortiously interfere with an advocate's business relationship. All of those claims had to be established on their own independent facts, and proving one did not prove the other. I think what the Appellee's main argument is that since Dr. White proving her wage claim meant that Island Pediatrics first breached the contract, and that proof of the first breach ultimately did release Dr. White from her responsibilities for breaching the contract, but that means the claims were inextricably intertwined. The problem with that argument is if we look at Palpinger, and it explains that the claims are only intertwined if you have to defeat the counterclaim in order to prevail on your claim. And the Appellate referred to the verdict form. I would do the same thing. If you look at the verdict form, it asks whether Dr. White is entitled to her back wages, and said yes. It then moves through her independent contractor claim, and then talks about the counterclaims that were asserted. The verdict form does not require that Dr. White prove that Island Pediatrics first breached in order for her to be entitled to her back wages. She was going to get those back wages if she proved her specific set of facts, whether or not Island Pediatrics was able to prevail on its counterclaims. And so they're entirely distinct facts. They're entirely distinct legal theories. And really, well, this is a question of law that this court reviews de novo to look at whether the claims were inextricably intertwined. As a matter of law, we believe that they were not. And so the only way for appellees to obtain any attorney's fees under Chapter 448 was to prove which fees they could separately allocate to that claim. The appellees took the position in the lower court that they could not do that. And in fact, at AR 3558, appellees counsel argued to the court, I can tell you, if you look at my records, you can't differentiate between the claims. And that's the reason that we're arguing that this court should not only reverse, but reverse and not remand. Because that would truly give appellees a second bite at the apple to take the entirely different legal position than what they took in the court below. There's two ways to prove the fees, either the allocation or that they're inextricably intertwined. They traveled the route, and the answer is very clear. They made the decision to travel the route of inextricably intertwined, presenting no evidence of the allocation, most notably not moving their timesheets into evidence. And so there is no competent substantial evidence to make an allocation determination. There is nothing for the trial court to go back and make any sort of determination on how you allocate the claims. They said they couldn't do it. They put on no evidence that would allow the court to do it. And so as this court remands, they're giving them a second chance to put on proof that they failed to do the first time around. The cases are pretty clear that it is the appellee's burden as the party seeking attorney's fees to be able to allocate. And if their time records are insufficient to do that, they don't get the fees. It is not the appellate, the party who would be paying the fees is not to be punished because the time records are insufficient to differentiate the claims.
If we find that they were inexplicably intertwined, do we need to remand for any other reasons?
Well, yes, Your Honor. Because there is still 57105 claim as well, which taxed my client, and the trial court did not attempt to split, or in fact did not split the attorney's fee award as required by 57105. And so there would be a limited remand to split the 57105 portion of the fees in half so that my client is only responsible for half of it. However, that is a limited need for a remand in this case. And I should also say to make the explicit findings of fact that are required by 57105, because that was not done here as well, because that order is sufficient on this case.
Okay. On the 57105, would we remand for a new hearing that they would bring back in the former counsel for the other side, or would that just go by the wayside and they have now?
As far as my client is concerned, and I'm only representing Island Pediatrics at this point, she cannot be charged in order with more than half of those fees. If the appellees chose to pursue Attorney Hall, they can certainly do that in another hearing, but that would not involve my client. There would need to be more evidence, and my client did not contest the reasonableness of the hours on that portion, only that she should not be taxed.
I'm having a little trouble following how you could do another hearing. How would either party, if the party wasn't properly notified, and I know it's not your client, but the lawyer evidently wasn't, how in the world could you take advantage of the safe harbor provisions of 5705 now? The trial's over. I mean, you can't withdraw a defense at this point.
Well, the entitlement was determined in a prior hearing, and so really the part that Attorney Hall did not get notice of
Was the hearing?
was the amount hearing.
Oh, I
The
see.
entitlement is already determined.
Oh,
That's
okay,
not
I
appeal.
understand.
Court have any further questions? I'll reserve my time for rebuttal. Thank you.
May it please the court, Alan Henderson of Henderson Law PA, on behalf of Appellate, K. White, ND, and her PA. My burden of proof, as stated in the Jura case, was either to allocate the fees incurred to the issues for which fees were awardable, which was the back wages claim, or to show that the issues were so inextricably intertwined that allocation was not feasible. That's the burden that I undertook. That's the burden that I believe we proved at the hearing that occurred January 31st, 2011. My proof came in the form of 2 attorney fee affidavits, my own, and that of my expert witness, Alan Winter, as well as Mr. Winter's testimony. It was cross-examined by trial counsel as well as by me. The hearing transcript from that hearing, which is in the record at 558 through 598, shows that there is competent, substantial evidence as to the number of hours incurred, the reasonableness of those hours, my hourly rate, the reasonableness of my hourly rate, and Mr. Winter opined, and he was there as an expert witness, based upon his complete review of my file, my timesheets, billing records, and the case law on when issues are inextricably intertwined, that they were, and that, he would not be able to allocate between the different claims.
Well, doesn't the wage claim and the contract claim, don't those claims cover different periods of time in which, during one period of time, there was an employment agreement, and during the other period of time, there was a contract agreement?
Judge, that's the
Why would
way.
it be easy to separate? That's what I'm asking.
Well, it wasn't easy to separate them because the central issue that permeated all of it was whether or not Bonnie White became an independent contractor as of June 1 of 2008 when they renegotiated the deal. And so the jury also had to determine when this new deal came forward, June 1 of 2008, was she an independent contractor or was she still an employee? If they had checked the box, she was still an employee, then obviously then all of the damages awarded would have been back wages. We probably wouldn't have been here. But what they determined was that that negotiation that occurred in June of 2008 was intended to amend the physician employment agreement. So throughout this entire 18-month relationship, you have the same physician employment agreement, but it changed June 1 of 2008. And so the breach of contract claim had to be litigated with the back wages claim. Obviously, we included the 448 claim to get attorney's fees. And then, of course, on the counterclaim side, the issues were identical. They alleged that Dr. White breached the physician employment agreement by leaving her, that she violated the non-compete, that she tortiously interfered. And if you look at the verdict form, specifically issues A1 and B4, you can see that because the jury determined that the appellant breached the contract first, her performance under that agreement was excused. They actually found that Dr. White did breach the physician employment agreement. They found that. But in issue B4, they found it was excused because of their prior breach. That's why it was so critically important to prove that initial breach during the first quarter of the relationship. The record is also very clear that the appellant provided no evidence whatsoever of the evidentiary hearing. There were no opposing attorney fee affidavits. There was no opposing expert witness. Nobody to say or to carry their burden that any of my time entries were inconsistent, confusing, or were capable of being applied to to an issue for which attorney's fees were not recoverable. So there was no evidence whatsoever submitted by the appellant to controvert my expert's opinion. My expert's opinion, the appellant's attack as not constituting competent substantial evidence, and would ask the court to throw out his testimony. I'm not sure what else Mr. Winter was supposed to do. And by the way, there were no objections to his affidavit. There were no objections to his answers. There were no objections to his qualifications as an expert. He testified, and his affidavit states that he reviewed my file in its entirety, including my time sheets and my billing records. He reviewed the case law on inexplicably intertwined issues and what that meant. He reviewed all of the pleadings. He interviewed me. I'm not sure what other factual basis he could have done to constitute the ground for his opinion that the issues were inexplicably intertwined. And that really is the issue, the main issue of the appeal, were the issues inextricably intertwined. Honestly, I don't know how you could reach any other conclusion. We've talked about the verdict form, specifically A1 and B4, those issues. But if you look at the case of Appellate Jackson Company versus Dubin, I think that case states very clearly what happened in our case, given the counterclaim. And in that case, that's at the top of page 172, the court held that claims are inextricably intertwined when a determination of the issues in one action would necessarily be dispositive of the issues raised in the other.
But the jury didn't have any trouble separating this out, did they? I mean, they actually specified a dollar amount for the wage claim. Obviously, they separated it.
Well, they did for the wage claim for that initial portion, and then they separated damages out after she left.
But doesn't the disparity between those, I mean, there was $916 for the wage claim and some $23,000 for the contract, or more than that, for the contract claim. Doesn't that suggest that the wage claim was really just a tiny part of this case? It was really and truly about something else. I mean, at least in the eyes of the jury, it was a case about something else.
I disagree, Your Honor, because when they answered the issue B4 on the verdict form, that Dr. White's breach of the employment agreement, i.e. leaving early, was excused because of their prior breach of not paying her what they were supposed to pay her. That was critically important. I mean, it's the same core facts. It's 18 months of what happened between these people with an intermediate renegotiation of how she gets paid. But to the jury, they hung their hat on the fact that you, the appellant employer, did not pay her what you said you were going to pay her from the beginning. And as a result of that, the appellant lost his breach of contract claim, lost his breach of non-compete claim, lost his tortious interference claim, and of course the abuse of process claim was frivolous. So I don't think it was a tiny issue to the jury. I think it was a critical issue as to appellant's counterclaims. Should my time sheets have been introduced into evidence at the January 31st hearing, Monday morning quarterbacking, sure. But I would submit by whom? Appellant's counsel had my time sheets. I provided them to him 3 months prior. He utilized my time sheets cross-examining Mr. Winter. I'm not sure if that constitutes a waiver of the issue or not, but he had, if you review the record at pages 585 to 590, trial counsel was utilizing my time sheets in cross-examination of Mr. Winter. He asked Mr. Winter if he received the actual detailed transaction file, and Mr. Winter said yes. In fact, on page 589, trial counsel admitted that the independent contractor issue was intermingled. So, Mr. Addington never tendered my time records into evidence to show that I spent a separate amount of time on a particular issue that's not susceptible to an attorney fee award. And I believe the law is that he had that burden. Burden shifts. Once there's a showing that the issues are inextricably intertwined, the burden then shifts to the other side to demonstrate there are some time entries that the court can pull out because they were spent solely on an issue for which attorney's fees are not recoverable.
Counsel, I'd like you to address the second issue, if the court pleases, on the sanctions. You cite no legal authority whatsoever in your brief to support the proposition that 100% of the attorneys, that the sanctions could be assessed against the losing party, when the plain language of Section 5705 says that the sanctions will be paid by the prevailing party, to the prevailing party in equal amounts by the losing party and the losing party's attorney. What case law or what statutory authority would support awarding 100%, assessing 100% against the losing party?
Yes, John, I would retract from that position. I agree with the language in the statute. I originally believed that the 5705 sanctions were going to settle against both the losing party and its lawyer, but I don't believe that is the case. So I think I believe if you reviewed the hearing, when the issue of notice to Mr. Hall came up, and he was inadvertently not noticed, and he was co-counsel for the appellant. He's the husband of the appellant. He withdrew from the case the last day of the trial. For oversight, frankly, but due to the procedural oversight and in hopes of getting the case resolved, I offered to not have any of the sanctions imposed against Mr. Hall and simply have whatever was awarded imposed against the appellant, or to have a subsequent hearing as to that issue. So I hope that answers your question.
I'm not sure it does. Are you conceding the second issue on appeal, or are you suggesting a different remedy that you sought in your brief?
I am conceding that the way to handle the sanctions portion of the appeal is either to remand with an evidentiary hearing where Mr. Hall is noticed and has a chance to contest the reasonableness of the fees, or to award half the fees against the appellant. I think that's what the statute.
What about on the same issue, counsel's point that there weren't sufficient findings in the order? It's another aspect of the same issue.
Your Honor, if there are technical deficiencies in the court's order with regard to specific findings of fact, I think that's easily cured by remand with instructions. The judge did make those findings. Unfortunately, it was in a memo that he sent to me. It's page 554 of the record, and unfortunately, those specific findings were not incorporated in the subsequent order. So, if it is technically deficient, based on his failure to recite those findings of fact, remand with instructions would seem to be the easy one. On the last point, Judge, where appellant sees a reversal without remand, I would suggest that would be an unbelievable, inequitable, and unjust result. The case law cited by the appellant for that proposition happens when the record is completely devoid of any evidence whatsoever on which the award could have been based. I would read from the Rodriguez v. Campbell case for a better proposition, and this is a worst case scenario from my perspective. That case says, however, when the record contains some competent substantial evidence supporting the figure cost order, yet fails to include some essential evidentiary support, such as testimony from the attorney performing the services or testimony from additional expert witnesses, the appellate court will reverse the remand for additional findings or an additional hearing if necessary. So if the court believes my timesheets are an essential evidentiary piece to this puzzle, then it seems to me a proper course would be to remand with instructions on the basis of either additional findings or an additional hearing. Thank you.
One of your arguments is that there were not sufficient findings in the order awarding attorney's fees as a sanction.
Yes.
Correct. How was that argument preserved?
In the motion for rehearing.
Okay. And so you raised this in a motion for rehearing, and the judge just denied the motion. Is that it?
Yes, the judge entered final judgment.
All right. Well, that answers that. Thank you.
I wanted to address the last point, that if there is any evidence in the record, and the counsel cited to the Rodriguez case, that you would remand instead of just reversing. Rodriguez dealt with whether there was evidence of the lodestar, whether there was some competent substantial evidence of the lodestar, the amount, the reasonable hourly rate, the reasonable number of hours, this sort of thing. That is not what is being challenged in this case. What is being challenged is whether the claims are inextricably intertwined, that is a legal determination, and absent a legal finding that the claims are inextricably intertwined, the only way for appellees to recover any fees under 448 is to separately allocate them, show which fees were separately allocable to that 448 claim, the wage claim. There is absolutely no proof in the record on that, and that is why we ask for a pure reversal, and not reversal without remand, because it's actually two different legal strategies. Appellees made the legal, tactical decision, much like you might in a trial, not to move for a mistrial if there is.
What is the proof of the total amount of fees that is in the record?
The proof of the total amount of fees?
He said that they were inexplicably intertwined, and he was able to prove up that this was the amount of time he spent, and this was a fair hourly rate, and fees were awarded.
Your Honor, if the claims are not inextricably intertwined, how much total time he spent on the claim is completely irrelevant. But we would also contest that you can prove claims are inextricably intertwined. It's a legal question. You look at whether they are alternative theories of the same wrong. And it's really no different from a motion for summary judgment. Appellees are saying, you didn't come back with any evidence. You didn't rebut my evidence. If you're wrong in the law, you don't have to show that there's a disputed issue of fact in a summary judgment. The law controls, and that's what we have here. The law that your claims have to be inextricably intertwined is what controls. There was no burden that shifted to my client to enter the timesheets to prove which claims were not eligible to the 448 claim, because they took the strategic legal position that they were inextricably intertwined, and we debated that on the law. But even if it is a proof question, we still stand by the position that Attorney Winter's proof of the claim being inextricably intertwined fails, as the main thing that he points to is primarily the jury verdict form, which, as we talked about, does not support the position that the claims were inextricably intertwined, and actually supports the exact opposite. The last two counterclaims, whether Dr. White tortiously interfered and whether she abused the legal process for deciding on entirely different facts, had absolutely nothing to do with first breach. You can tell that from the verdict form. You can also tell that Dr. White, once the jury determined that she was entitled to the $900 in back wages, she was entitled to that regardless of whether there was a first breach or what happened at the end of that relationship that entitled her to the independent contractor damages. And Judge Hodgman, as you pointed out, the jury had no problem determining between those two amounts. And so Attorney Winter's testimony and his affidavit, it really was nothing more than testifying as to the ultimate fact, or the ultimate legal conclusion, when that's exclusively the province of the trial judge. So we would ask that you reverse and remand, as we discussed, for the limited portion of the splitting the sanctions, but not remand with respect to the entitlement to fees under Chapter 448.
Thank you. All right, we'll call the final case on the calendar now, which is the May Inc. v. Jennings Court LLC. Counsel for the appellant, may proceed.
May it please the court, I'm Michael Ward, along with trial counsel Mark Appellate, I represent the appellant May Incorporated. We ask for 3 minutes of our time for rebuttal. Your Honors, the appellant may respectfully request that this court reverse the lower court's order dismissing proceedings supplementary on the grounds that the court applied the wrong legal standard. There are 2 points that we are making on appeal. The first point is that the trial court erred when it determined that the May could not use the equitable theory of